You're still live with us here on TV3. There's some development from the country's apex court, which we're bringing to you right now. Two trending matters which the court has made determinations on. The first involving the independent prosecutorial powers of the Office of the Special Prosecutor. We know there was a challenge by a private legal practitioner, Noah Damte, in relation to whether or not the Office of the Special Prosecutor could independently and in of itself prosecute matters independent of the prosecutorial powers vested in the Attorney General by Article 88. The court has returned a verdict this morning which says that the independence of the Office of the Special Prosecutor within the framework of legislation as passed Act 959 continues to remain, but the Office of the Attorney General can still file a nolle prosequi in the matters involving the Office of the Special Prosecutor. It's a huge one because we know that prior even to this determination by the Supreme Court, a high court had ruled asking the Office of the Special Prosecutor to write to the Attorney General seeking a fiat, amongst other things, to allow it prosecute cases. It has resulted in a pending of all other matters involving the OSP and cases it has before the High Court, pending or awaiting this determination by the Supreme Court. Now we have this verdict. Exactly what does it mean? That's the court even, or did the court even speak to that ruling by the High Court which asked the OSP to write to the Attorney General asking for a fiat or requesting a fiat to prosecute in its name? All of that and more is what we're bringing to you right now. And we're going to start from the court where my colleague Lord Eduasari and Sixtus Don Ulo are stationed outside of the Supreme Court where this verdict has been coming through. And I'm touching base first off with them. Sixtus is joining us right now with a bit more in terms of details along with my colleague Lord Eduasari. Gentlemen, I appreciate you joining us. Fill us in on the details, what the basis was for the court or the justices in arriving at this decision and what it means going forward as well for the office.
That you gave. The reason for a lot of us, the reason that Noah Damte came to the Supreme Court was to put a finality to that raging debate at the time. If you recall, at the time that the issue came up, it was in respect of some of the high political cases that were before the High Court, and also in respect of the extradition processes that the OASP was seeking or pursuing. Necessarily
law of the Office of the Special Prosecutor. Apart from that, the Supreme Court has only identified a problem that is within, if you like, the constitutional structure. Because if you look at the way the framers of our Constitution 1992 couched it has placed the burden of prosecution, which is what you would hear the lawyers refer to as the prosecutorial powers, on one single office, and that would be the Office of the Attorney General. And so you would find that all prosecutions begin and end with the Office of the Attorney General. always led by the Attorney General, whether directly by himself, his deputy, or by any representative
of the Attorney General. In times past, you have seen former Attorney General Godfrey Dame himself in court on some of the high-profile cases. In present time, we are seeing the Honorable Dr. Justice Ramsay, who is Deputy Attorney General, also at the fore of a lot of all of these high-profile political cases. And so, Attorney General is leading the charge himself. Or you would find some state attorney, senior state attorney, who is running that particular prosecution. That is singularly because of the Constitution, placing the burden of all prosecutions squarely on the shoulders of the attorney, which are then delegated. Again, the other conversation that came up was whether the office of the special prosecutor, a specialized institution set up to fight corruption, to prevent corruption, and also to ensure that the cost of corruption is set in our country. If you look at the historical antecedent of the establishment or creation of the office of the special prosecutor, this is what you would find. So whether we needed
to prosecute cases independent of oversight, of supervision of the office of the Attorney General. That has always been the lingering question, right from the inception, the discussion stages of the bill that established, or the law that established the office of the special prosecutor. That has always been the question. Are we going to have an office which independently, in the sense of all the meanings of the word, independently investigate and prosecute corruption and corruption-related cases? Or you are going to have an office which in effect is there, but still has oversight from another institution. And so if you look at the opening sections of the Office of the Special Prosecutor Act, this is what you would find, the mandate and the objects of the office. But the question is whether, in view of the Constitution, you can have an office that has independent prosecutorial powers. And that is the question that the Supreme Court sought to answer in this particular case. And the Supreme Court says that, well, if we want to have to this matter, we may have to look at an amendment to the law that would then give it, ensure that we have an office that has independent, will not have any oversight responsibility from any other institution or department or office. Now, the reason that is important, Mawuena, is that if you have a case that is a very conflicting political case, you have a case that let's just assume without admitting that there's a case that the Attorney General has to prosecute, corruption related, party is related to the Attorney General, or the Attorney General has an interest in that matter. Will the Attorney General be independent in that particular matter? Or let's even assume, once again, that this involves another high-ranking government official who must be prosecuted.
Right. Six, I'm going to have to hold you just there and come back to you again as to what all of this possibly could mean. But let's get on to the phone lines right now. Private legal practitioner Martin Kpobo is one individual who's followed this keenly, and the understanding I even have is that he was present in court when the justices of the Supreme Court arrived at this decision this morning. Counsel, I appreciate you for joining us and for holding the line as well. I've just been hearing a bit more from my colleague Sixes as well in relation to what this means, but you are in court painting all of this, right? What this means for the independence conversation which we've had in relation to the office of the special prosecutor, and the fact that the court says that the AG can still file a nolle prosequi. It brings us back to where we were before, does it not? Counsel, can you hear me, please?
Hello?
Yes, Counsel, can you hear me now?
Yes.
Great. I'm asking if this decision does not return us to all of the conversations we were having before, that the Office of the Special Prosecutor can go ahead, investigate, and prosecute matters, but in the end, the AG can still have the final word and decide to file a nolle prosequi. It brings us back to where we were before even this case went to the Supreme Court for a determination.
Not exactly. No. There's a big change. The big change being that the Office of Special Prosecutor was actually arguing that the AG cannot enter nolle prosequi. The AG does not have any supervision over them. That's the argument they were making, which was very ridiculous in the face of Article 88. So this decision is fair. It's okay for now. And when I say for now, you cannot blame the Supreme Court. That's the state of the law. So rather, what we have to do is to continue the advocacy for us to amend the Constitution to give the office true independence. But when we are giving true independence, what we are learning is that you can't just give true independence without true accountability.
Right.
So this whole lawsuit came about because we didn't see the Office of Special Prosecutor being accountable. There was no accountability. That's the problem. That's what brought this lawsuit. You know, the matter, look, let's be plain. The matter of Oforiatta, the way to say they didn't investigate it and allowed Oforiatta to flee, and then later he was lying around that he sought to arrest Oforiatta but didn't get help. That is what had brought this whole suit about. So now with this Supreme Court decision, what it does is that it now holds him in check so that the arguments that they are independent of the AG has been thrown away. And it's okay for now, because if you can't remove the person, remember I put in a petition for its removal and people went to beg, so it's not seeing traction. So this is better, that the Attorney General will control him for now. But the key thing is that let's return to the advocacy that in the new Constitution, we want true independence for the OSP, but we also want true accountability of the OSP. The two should go together.
Right.
At first, we're just singing independence. We forgot accountability. And now we've learned it the hard way.
Where does this leave us in terms of the fight against corruption? Because remember, the argument which was advanced for the creation of the office even was that the AG's office was a political office and they will not have the ability to prosecute their own. With this determination, yes, you described it that the argument was ridiculous amongst other things. It brings us back to square one with respect to the fact that when an investigation should start and start against a person possibly with this government, there is the ability of the AG to file a nolle prosequi. Yes,
it's better. Look, for now, from where I sit, it's better. Because the problem we are faced with is a special prosecutor who is aiding some other persons to evade justice. So once the special prosecutor is aiding some people to evade justice, Oforiatta, listen, it's better that we have this control. Now, let's come to this. If the special prosecutor is prosecuting an NDC member and the AG just enters nolle prosequi, don't forget that he has the people of Ghana to contend with. We'll have to go into it. And the AG is one person who gives reasons for nolle prosequi. If the reasons are not good, we would ask for the prosecution to continue. Don't forget that when he entered the last round of nolle prosequi, he agreed that for the Collins Dada matter, he's going to investigate it. And so the Collins Dada matter is not a closed chapter. So all in all, I believe that for now, Ayene is a better person to supervise the whole system than leaving Kissie Ejabin unchecked. The way Oforiatta have absconded is a big lesson to us, and all the other matters are put in my petition. Please, let Ayene supervise him. Let's also work hard to amend the Constitution to give true independence to the OSP and also true accountability.
Right. The next phase will be what happens next, because remember, before this determination by the Supreme Court, the High Court High Court in Accra had ruled asking the OSP to write to the AG seeking prosecutorial powers. It resulted in a stay in all of the prosecutions being carried out by the Office of the Special Prosecutor. What does this ruling mean for that High Court decision and the subsequent prosecutions in the High Court, which have all been stayed as a result of that High Court decision?
Okay, so the Supreme Court is saying that the cases that are pending can continue. Any convictions that have been obtained already are also valid, which is good. But then the decision of the High Court is also good because now it makes clear that when the OSC is working, he would have consultations with the AG. He will have consultations. So I don't think really. So let's say in plain words, the part of the High Court decision that stops all prosecutions or declares all prosecutions null and void, that side has been overturned. Yes, that side has been overturned. But the other part of the High Court decision, which is the spirit of it, has been upheld by the Supreme Court, saying that, listen, you are not independent by yourself. You should always have consultations with your boss, the AG. But the special prosecutor will say otherwise. So you won't say the whole of the High Court decision is bad. And you see, understand the High Court decision in the context that the people who went for that High Court decision are saying that the special prosecutor has a special relationship with a certain person who is instrumental in the prosecution of those persons. Let's repeat. You see, don't just look at the decision is not hanging in the air. The people that were being prosecuted in the High Court, their beef is that the man who has a case against them, a certain ex-customs officer, is close friends with Tisi Ejabin, and so he was using Tisi Ejabin to prosecute them when they have a good case, the rights, etc.
Right.
So please, it's justice for these people. It's justice. We just don't say,
Counsel, some of those matters I have no knowledge of, but it will also mean that going forward, there will be no writing asking for authorization in new cases, in the cases which are currently before the courts. And so even for this case, which you're making reference to as to an allegation of the office being used and whatnot, which we cannot independently verify, that case will proceed.
Yes, that case like this, yes, you are right, that on paper is supposed to be to proceed. But now with the decision of the Supreme Court, I expect that those guys are going to petition the Attorney General and he's going to stop that trial one time. I have no doubt that if those guys put together a petition, from what we know, look, that customs officer is well known to be a friend to Tisi Ejabin, and if you understand the facts of the case, this is one case that I expect Dr. Ayine to enter a nolle prosequi to stop that trial. It's an abuse. So the man, it's an abuse. So that's why I'm saying this decision is a victory for the guys. Yes. So the High Court judgment, I don't see it as a useless thing. It's actually the precursor. This is how public arguments are won. Right. The High Court judge did his bit. Yes, the spirit of his thing has been upheld because now through that, the Supreme Court has said that the Attorney General can stop the trial. So when he stops it, nobody will say, hey, he's interfering. Nobody will say so.
Will this not then open the books, right, that it will have persons who the OSP is prosecuting begin writing to the Attorney General and saying, file a nolle prosequi in this case for me. Yes, we expect the Office of the Attorney General to, on its own, independently verify. Then that will begin to bring in a certain oversight, wanting to pour into what investigations the OSP is engaged in, and that will directly then be breaching the OSP's Act 959. So there is a problem somewhat if persons can begin to just wake up and petition the Office of the Attorney General to file a nolle prosequi in an investigation being carried out by the Office of the Special Prosecutor.
No, Name, I disagree vehemently with you on this point. There is no problem. Rather, the Supreme Court has solved the problem where the Special Prosecutor was abusing the powers to prosecute people who have a fight with his friends. Where the Special Prosecutor was abusing his office to let some people flee. Operator is fled. Operator is fled. Operator is fled because he said they are being allowed him to flee. So this Supreme Court decision now puts the special prosecutor in check. So we should be very happy that, like I said, because you will not always get an attorney general who may have a good character like Dominic Ayene, our best bet is that let's amend the constitution and give the special prosecutor office true independence, but also true accountability, transparency. So for now, for me, I see it as a problem solved because you have no idea. No, maybe one day I should let you read the petition I presented to the president for the removal of Kisi Ejabe. You weep. You may even get up and say you want to go and remove him by yourself. Please, don't play with this thing. Let people who have been to that office talk to you and you will understand. So the true thing with length, I keep saying from this case is that a law does not necessarily guarantee that the person who comes to the office, who comes to implement it, will have the character of an angel. A law by itself, so far from the way we've been drafting, we've not drafted the laws to keep the person in check. So this Supreme Court decision is a welcome one to keep the special prosecutor in check until we develop laws that can properly keep him in check. So it's a problem solved. You have no idea the abuses going on in that office. You have no idea. You should send cameramen underground yourself. Right. Then you will know. Even the workers themselves, a lot of them are unhappy. The abuses are a mountain. Please, this Supreme Court decision is good so that Ayene can curb the excesses. Very, very good. But we also recognize that Ayene will not always be the Attorney General. So we are back to square one, which is that let's amend the Constitution to put in place a measure that will ensure that the next Attorney General will not unduly interfere, and also the next special prosecutor will be held in check. That's what we need. So we need to improve the law. Yes, it's a continuum.
Counsel, I appreciate those details, and it's Mawuena here. It's Mawuena.
Mawuena, okay.
Yes.
Mawuena, forgive me.
Yes, Counsel, I'm sure we'll engage again subsequently on this subject matter, but I appreciate you making time to speak to us. That's private legal practitioner Martin Pebu speaking to us this afternoon. It's still morning, right? It's still morning. I'm usually around by the afternoon, and so it's a temptation to say afternoon. But we're going to go back to the courts right now, where my colleague Sixtus is on standby with a bit more in terms of, because remember, it's not just this decision by the Apex Court. There's another, right, in which Professor Frimpong Boateng and a host of others had gone to the court asking that the delegate system of political parties be thrown out and allow for all persons registered with a political party vote, right? And the court has upheld that decision, which means that the delegate system, which has existed for a very long time, no longer exists. But Sixtus Strong Ulo is joining us again. Six, you were rounding up submissions in relation to the office of the special prosecutor. I just want you to finish on that front. Then I begin to get a bit more in terms of details on that other major ruling and how it affects political parties going forward as well.
Yes, that is so. So let me do that wrap with my colleague Lord Edua Sari. In respect of the specific decisions. Let's just break it down. This is what the Supreme Court said. The key things that the Supreme Court said on the issue of the OASP in its relationship with the Attorney General, and then we can go on to the next. And so my colleague Lord Eduasari will help us do that. The Supreme Court, number one, did not rule that the sections 3 and 4 of the Office of the Special Prosecutor law are problematic. That is not the decision. What exactly did the Supreme Court say on this one?
So the Supreme Court rightly indicated that as far as the Article 3 and 4, Sections 3 and 4 are concerned of the OSP Acts, they are not in contravention with the Constitution, and so essentially the special prosecutor has the mandate to prosecute cases. And then citing Article 88 regarding the Attorney General's authority, they added that the Attorney General now has the mandate to, as it were, file an only prosecutor or discontinue any case that has been started by the OSP. And then they also added that any case or all the cases which have been initiated by the OSP even before this whole challenge started remains valid. And so basically that was the summary of the decision of the Apex Courts, which was presided over by the Chief Justice Paul Bafuboni.
So 3 key things we can pick. Sections 3 and 4 of the OSP law are valid law. They are not in conflict with the Constitution. Number 2, the Attorney General, the Office of the Attorney General has what you would want to call supervisory authority over the cases that are initiated by or prosecuted by the Office of the Special Prosecutor. And that is exercisable through what we call the discontinuation of cases. So the Attorney General can decide that a particular action that has been instituted, corruption or corruption related, he is going to enter a nolle prosequi. That is to say that to discontinue the prosecution that has already been started by the Office of the Special Prosecutor. And number three, all the prosecutions that are already initiated by the Office of the Special Prosecutor remain lawful and they can continue in through their full course to their valid conclusion. These are the 3 key things that we can pick from the decision that has come out of the Supreme Court this morning. And that panel was chaired by the Chief Justice himself, Justice Bafuboni. But the civil society organizations who applied to join themselves to this particular case, they were in this particular, in court today, they listened to this. Were they satisfied with the decision that they got from the court today?
I mean, largely they were. We spoke to Professor H. Kwesi Prempeh of CDD. He indicated that, yes, ultimately this is what they have been gunning for from their advocacy. You recall that they indicated that even before the Office of the Special Prosecutor was set up, some of these civil society organizations were consulted. And so largely what the Supreme Court is saying is very satisfactory, and this is their position on it.
So we will be listening to some of the interactions that we have had with some members of civil society who took a large interest, a huge interest in this particular matter. But Mawuena, I don't know if we'll listen to that now or we will go on to the second issue.
Right. So, Six, here's how we're going to do. I'm going to walk viewers through a bit more in terms of details from the court as you've explained, and then we will listen to exactly what it is that they've been saying, the reactions which have come forth from this Supreme Court verdict, this decision. And the individual who took the matter to court, Noah Damte as well, has been writing on Facebook, essentially arguing that reliefs A and H, right, which he took before the court, has been granted. And arguing as well, amongst many other things, that the Act 959, and then the legislative instrument subsequently, either one of them has ceded some of the AG's prosecutorial powers to the Office of the Special Prosecutor, and subsequently the AG can revoke same by an amendment of the legislation before Parliament, right? But let me take you onto the dashboard right now, and then we can do a bit more in terms of the latest we're learning of from the Office of the Special Prosecutor from the Supreme Court, right? And that's where we're going right now in relation to the subject matter, which we've been bringing to you in the last 30 minutes, almost 30 minutes. Yes, so here we are in terms of the arguments as was advanced by the plaintiff, Noah Damte, that he had argued that Parliament could not create another institution with prosecutorial powers without first amending the Constitution, because Article 88 places, vests the Attorney General with all of the country's prosecutorial powers. So the police, customs, all of the other institutions, NACOC and the likes, who investigate or prosecute matters, prosecute, do so on the authority of the Attorney General. The Supreme Court made a decision that they rejected the interpretation and found that the act establishing the OSP did not unlawfully remove or replace the Attorney General's constitutional authority. And so pretty much the AG still remains Lord of all in terms of criminal prosecution in the country. And he subsequently ceded same to the Office of the Special Prosecutor by either Act 959 or the legislative instrument. It's not really clear which one, but it presupposes there is a ceding which has been done. And so there will be no requirement, and you heard me when I was asking those specific questions to private legal practitioner Martin Pebu as well, as to whether there will be a requirement going forward for a writing. Because remember, the High Court, right, a High Court, not the High Court, a High Court had ruled and argued, made decisions or determinations asking the Office of the Special Prosecutor to proceed right to the Attorney General's office for authorization, a failure of which the Attorney General's office would have taken over the cases which were being prosecuted by the Office of the Special Prosecutor. What this decision by the Supreme Court does is that it pretty much says, well, the authorization was granted when the act was passed, and so they proceed nonetheless, but the Attorney General continues to remain Lord of all and can file a nolle prosequi as and when. Now, the Supreme Court also affirmed the constitutionality of Act 959. One of the arguments was that the act which created the Office of the Special Prosecutor, Act 959, it went through Parliament, it was presented to the 7th Parliament by then Attorney General Gloria Kufu. The argument was that it was unconstitutional. Simply put, it contravened sections of the 1992 Constitution. And if you ask your lawyer friends, they'll tell you that anything which goes against the 1992 Constitution is automatically deemed unconstitutional. The court made a determination as to whether or not the act, the law which was passed, which created the Office of the Special Prosecutor, was done according to the dictates of the 1992 Constitution, a failure of which would have meant that the OSP's office was moot, all of the investigations and prosecutions and convictions they've secured, there would have been challenges, right? Challenges of same. The Supreme Court arrived at this decision that, yes, it's consistent with the 1992 Constitution. There is no part of it which suggests that the 1992 Constitution, which is the longest serving, really, in the country's history. Next year we turn 70. It followed the dictates purely, and there can be no argument as to an aspect of it not following or meeting the requirement in relation to the 1992 Constitution. The OSP can initiate and conduct prosecutions. Obviously, we've been speaking to you about that ceding of powers in Article 88.3 has been pretty much affirmed, and so they can proceed and initiate investigations. But, like I've been telling you, the Attorney General's office can file a nolle prosequi. They can intervene and say that, in this case, we are discontinuing. Because, like I was telling you, the Constitution, from which all other laws must flow from, says that it starts and ends with the Attorney General, criminal prosecutions. And so they will continue to hold that power over the head of the Office of the Special Prosecutor, despite the OSP being able to initiate prosecutions in and of themselves. They are independent, but they are not beyond Article 88, and that's pretty much all of the argument. Let's take you back to the courts right now and take a listen to Professor H. Kwesi Prempeh, as well as Dr. Kojo Asante Pompuni, all of the CDD, react to the determination by the Supreme Court.
I agree. And I think, for me, this is, first of all, it's a landmark decision. And I think it's really courageous on the judges to actually, get ahead of the issue. Because
if you look at the proposals that have been made for constitutional reform, direct elections is one of the things that, yes, there's an argument that it can reduce vote buying, but they also are saying we have unfunded mandates. Who is going to pay? We have made recommendations that what we are calling the Democracy Fund, or even some of the costs, if the Electoral Commission is overseeing elections, it should be borne by the state. So that we have to meet halfway to make sure that our parties don't have to now go look for money to come and do, and then they get into all kinds of vote buying and other kinds of illicit money issues. So we should affirm the principle. Now it's really the mechanism. How do we ensure that we reduce the cost of elections for all of us, for all our benefits?
Do you think that the Supreme Court should have considered this idea of the state bring up fund? Because then again, if the cost becomes too high, the political parties may go to sources which will eventually bring back the corruption which we are seeking to avoid.
You see, the Supreme Court is answering questions. So the question was whether or not, in principle, we, having a system that is not allowing other people to vote is consistent with Article 55 and so on. And they said, no, we should, to be consistent, we need to have direct elections. The next step now is they give them a year. And that's where I think all of us, should engage, and I think civil society should engage. What should be the systems that I really believe that we need to revisit the political parties law, because internal regulation of parties, that leaves it to just the constitution, is not sufficient to guarantee us the things that we want from political parties. So maybe this is a good conversation for all of us to have.
Thank you very much.
I mean, some of the issues you had already raised in the constitutional review report. 8 months down the line, it hasn't been implemented, or the government position hasn't been indicated. How does that bear on everything that's happening?
I am really hoping that this week the government position paper will come out, because you recall that Mr. Felix Ofosu-Kwakye did raise, I think 2 weeks or 3 weeks ago, that last week was going to be the government publishing of the government position paper. We're all waiting for it. So I'm hoping, maybe because the last week was the Wuntubi case and other things came up, but I hope that this week it is published, because we are already losing time. If we want to amend the constitution, both unentrenched and entrenched clauses, the gazetting period is 3 months and 6 months. So we don't want to get into the thick of the political season.
That's Dr. Kojo Asante Pumpuni speaking to the subject matter of the delegate system, right? The delegate system, which means that all card-bearing members of a political party in good standing can vote to elect flag bearers, parliamentary candidates, amongst many other things.